Hi guys, let's now discuss the object of the contract of sale. As we all know, there are three essential elements to the contract of sale. These are consent, object, and cause. So let's now discuss the object of the contract of sale. For an object of the contract of sale to be a valid object of the contract of sale, it must be within the commerce of men. When we talk about commerce of men, it simply means that it must be capable of being owned, possessed, and acquired and transferred to another person. So an example of object that is within the commerce of men, the car, the chair, the table, the clothes, the shoes, these are valid object of the contract of sale. An example of things that cannot be a valid object of the contract of sale because it is not within the commerce of men are the public roads, public parks, the seas, and the moon. These are not within the commerce of man. The second one is that for an object to be a valid object of a contract of sale, it must be licit or legal. So although several times we hear in the news that there is a transaction of buying and selling of shabu or marijuana, uh, this these are object of the contract of sale, but these are not valid object of the contract of sale. So if there is a contract of sales selling a truckload of shabu and one party will not perform his obligation, of course, the other party cannot go to the court and ask the court to compel the other party to deliver the truckload of shabu because it is not licit or legal. The third one, for an object to be a valid object of the contract of sale, it must be determinate. However, future things can be a valid object of a contract of sale. When we talk about future things, these are things having potential existence, like for example, the sale of expected thing, which is INCHOATE REI SPERATAE, and the sale of hope, which is INCHOATE SPE. An example of sale of expected thing or INCHOATE REI SPERATAE are, let's say, for example, the possible produce of a mango tree. Your mango tree is now flowering, and so though there are no fruits yet, that can be a valid object of a contract of sale. Or the possible produce of this season's planting of rice, that can be a valid object of a contract of sale. Or the possible wine that can be produced out of the grapefruit. So these are what we call sale of expected thing or INCHOATE REI SPERATAE. An example of INCHOATE SPE or sale of hope is a sale of raffle ticket, a sale of lotto ticket, or sweepstakes ticket. These are what we call sale of hope. Actually, you are not selling the ticket itself. So let's say, for example, the ticket's price is 50 pesos. It's not really the value of the ticket that you are buying, but the possible chance of winning the grand prize. So these are what we call sale of hope. What if, for example, if the ticket, a raffle ticket that was sold is already drawn, so the law said it cannot be a valid object of a contract of sale because it is now a sale of vain hope. All right? The sole owner of the thing may sell an undivided interest therein that produces the effect of co-ownership between the buyer and the seller. So let's say, for example, if I have a one-door apartment, then I am selling 50% of interest uh, to you, okay, to you. So what is the effect of that is that we will become co-owner of this one-door apartment, 50% owned by you and 50% owned by me. There may be a sale of an undivided share of specific mass of fungible things, though the seller purports to sell and the buyer purports to buy a definite number of weight or measure of the goods in the mass, and though the number of weight or measure of the goods in the mass is undetermined. Still, it is considered to be a determinate thing. So let's say, for example, if I have a truckload of rice, and you wanted to buy 500 kilos out of it. So that can still be a valid object of the contract of sale, even though we did not determine yet uh, the the number of sacks that you are going to buy from the truckload of rice. You need to take note, guys, that a sale of future inheritance cannot be a valid object of the contract of sale. An inheritance is considered to be a future inheritance when the owner of the thing is still alive or there is no death yet. Because as we all know, in the law on succession, it's death that opens succession. So if your father and mother died, that opens the succession. Though you do not know how much that you will inherit, you can validly sell whatever you will receive from the inheritance. But if your father and mother are still alive and you are selling your future inheritance, that cannot be a valid object of a contract of sale because it's still considered to be future inheritance because succession is not yet open. Last thing, guys, when it comes to object of the contract of sale, is that the ownership of the vendor is not required at the time of sale, but the ownership of the vendor is required at the time of delivery. So you can sell something this time, even though you are not the owner yet, but in the future, you must be the owner for you to deliver it because it's delivery that transfers ownership and not the sale. So these are the basic considerations that we are going to, you need to take note, guys, when it comes to the object of the contract of sale. Bye, guys.